How do you beat your first domestic violence charge? I kind of stumbled on that a little bit because as I read the question, I thought to myself, what do you mean first domestic violence charge? Does the question anticipate that there will be others? So that threw me a little bit. But I want to tell you, it's a good question nonetheless, and it deserves an answer. My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public. So please subscribe to our channel. So how do you beat your first charge? Let's use the language of the questioner who asked it to us. You have a charge. You're charged with domestic violence. Hopefully there won't be another charge. Hopefully it won't happen again. But what's the best way to do it? Well, there are different ways to approach this. It's going to be very specific. So for example, if there was an argument between, let's say, husband and wife, and a neighbor calls the police, and then they come and they have to take someone away, so they take the wife or they take the husband, whatever. It may be a little simpler because the husband and wife had a way of dealing with each other. Maybe they screamed a lot. Maybe they threw things at each other. Maybe there was some inappropriate, aggressive physical contact that they probably shouldn't, but maybe that's what they do, and they never thought to involve the police. Well, if that's the case, I'll tell you one thing, a no-show will help the case get dismissed. If husband just decides, you know what, yeah, I know she did that to me, but that's kind of how we're very, we're very emotional people, we're very physical people, and it's not a police matter. This is a private matter. I'm not showing up. If you make that decision, you know what's going to happen? There'll be a pretrial. You won't appear. The court will set the matter down for trial. You won't appear, and they're going to dismiss that case. It's going to die on the vine. Now, the prosecutor will try to get the other person to come in. The prosecutor will try and send you notices. You need to come to court. You can't let her get away with this, all that stuff. But the truth of the matter is, if there's a no-show, your attorney will file a motion, either oral or written, and say, Your Honor, there's no complaining witness here. And the judge, frankly, is not going to care more about the case than the victim. So that case is going to die on the vine. Now, what if the person does show up? Well, there are other things. For example, a person can argue that it wasn't a violence as such. You were just defending yourself. Somebody shoved you and you just sort of moved to get away and somebody fell. There are ways that the court can take proofs and take testimony, and the court or jury can decide, you know what, this was not done as an act of violence. This was purely self-defense. The other person was the aggressor, and we're going to dismiss the matter. So those are possibilities. But remember one thing, when you go to trial, you never know how the facts are going to be perceived. I can't tell you how many times clients will tell me, I can't believe I lost. I don't know why they didn't see it my way. Well, they don't see it your way because, every time somebody says, that she threw me out, the other one says he abandoned us. In other words, there's always two sides to every coin, and they're not necessarily going to see it your way. The best surefire way, a no-show, generally will mean that the case is going to be dismissed. If you have any questions about that, reach out, and we'll be glad to help you out.